I'm Kat Jones. I'm the director of APRS, which is Action to Protect Rural Scotland. And we've gone into partnership with Planning Democracy to create a number of webinars over the winter. Now, this first one is organised by Planning Democracy. Claire Simons, who many of you will know, if not all of you, very familiar. Thank you to her for the effort that she's put in. We're going to be hearing from Alasdair Edwards from the DPEA, and Claire will be able to give him a proper introduction. But before we get started, I just wanted to say that we've got lots and lots of questions already submitted, and thank you to those people who already submitted your questions. We're going to hopefully all the way through, things will be popping up, things you'd like to ask. Please type them into the chat, because it means that we can perhaps field them into groups, make sure that we're making sure that everyone's questions is asked at the right time. So we're going to start with an opportunity for Claire to say a bit of an introduction to why we're here, what we're talking about, and then she'll pass on to Alasdair. At the end, there will also be a chance to, we'll put some links up for donations, because APRS and Planning Democracy don't have funding to run these webinars, and so it would be great if you could help us along with that. So let me pass on to Claire. Such a familiar face in this area of work, and I'm completely brand new to this, so I'm really looking forward to myself to learning a lot today. So Claire, on you go.
Hello everybody. Yeah, Claire from Planning Democracy. As many of you will know, we're a grassroots campaign organisation, and we campaign for a fairer, more inclusive planning system in Scotland, and one that puts people and planet at its heart. And we've been working with APRS for quite a while now, behind the scenes, I guess. And as many of you know, we campaigned for changes to the 2019 legislation, and APRS put in their hard work to that, as well as the PD network. So that legislation gave greater weight and significance to Scottish planning policies that are contained within the new National Planning Framework 4. And we knew that NPF 4 was going to be important, and so we worked really hard with APRS and many of you in the network to make sure that it was as good as we could get, and so that it really did put sort of people and planet at its heart. And I'm pleased to say that NPF 4 is as good a document as we could probably hope for. Whereas previous national plans placed the emphasis on delivering economic growth, this plan puts the emphasis on climate and biodiversity crises. And we think this could be an absolute game changer in terms of protecting nature and the planet. So we therefore sort of see it as a hopeful document. In addition, I guess many of you were concerned about housing developments, and we hope that NPF 4 might help ensure that the right kind of housing, i.e. affordable or social housing, will be built in the right places. And what we mean by that is ones close to transport links, and with the resources and the infrastructure that can help people who are living in those areas, maybe using vacant or derelict sites, for example. The housing policies in NPF 4 were a little less radical than we would have liked, so the jury is out as to whether or not NPF 4 will be able to deliver on housing for those who need it in the right places. But so well done us on NPF 4 in general, and congratulations to the government indeed. But now that it's been adopted, local authorities are required to redo their local development plans in accordance with NPF 4. And that means that there's more work for us to do to make sure that the local development plans reflect those good policies in NPF 4, and also make sure that community needs are taken into account. So we thought it was really important that people knew how the LDP works, what it is, how, when and why to get involved in shaping it. Now, these take about 3 to 4 years to draw up a local development plan. So there's only certain times when you guys can get engaged or get involved in it. So it's really important to understand the process. So in a minute, I'll go to welcome Alasdair, who's going to take on the challenge of telling us all about local development plans and putting them in the broader context and explaining how you can get involved. But before I do, there's some additional resources that I think Barry might be putting into the chat, and we will send on in a follow-up email after this webinar. But APRS have made some fantastic resources explaining about the local development plan process. So we'll send that link. They're also doing the DPEA and APRS have sort of drawn up a list of all of the local development plans when they're due to be developed. So you can check your own local development plan and find out where it's at. There will be checklists and prompts to help you work out what you need to put into the evidence gathering stage, which you'll see is the first stage of the local development plan process, and APRS are going to help you with that. And look out for blogs from Planning Democracy. Sign up to our PD newsletter, and we will have some of the follow-up questions to the many questions that you will have already asked and will be asking tonight. So we'll make sure that you get answers to all of those questions, because there's not going to be a chance to respond to all of them. And also we have a blog that contains lots of helpful information about local place planning. And hopefully Alasdair will have time to touch on local place plans as well as local development plans and get into all the jargon. So without further ado, I'd like to say thank you very much to Alasdair for giving up his evening. He's, as you can see from the first slide, he's the principal reporter, a principal reporter at the Department of Planning and Environmental Appeals. And I know one of his slides is going to introduce himself. So without further ado, thank you very much, Alasdair, and take it away.
Okay, well, firstly, a thank you to Planning Democracy and Action to Protect Rural Scotland for the kind invitation to come along this evening. I thought initially I'd be talking about just local development plans, but the title came through Understanding Scotland's New Planning System. So I've got quite a bit to get through over this session tonight. I'd like to thank all of you for attending tonight, and also anybody watching this at a later time for taking the time to watch it. There was a previous talk by a colleague of mine called Dan Jackman about development planning and the DPEA and the caseload that we undertake. And a link to that and the YouTube filming of it, I think, is available on the Planning Democracy website. So certainly if you've enjoyed tonight, then you can go and have a look at that as well. So tonight, I'm going to give you an overview of, well, firstly, a caveat, and I'm sorry about that. I'll come to that in a minute. I'm going to talk about who I am, what a reporter is. I'll set the scene slightly because we can't understand the planning system in Scotland without knowing why we have a planning system. So I'll talk a wee bit about planning history. I'll talk about the recent changes from the Planning Scotland Act 2019, what the development plan is, what is contained within the National Planning Framework 4, the process of local development plans, and associated to that, the local place plans and regional spatial strategies. We'll also talk briefly about the other work that DPEA do and how we come to decisions and our recommendations. And then, as Claire said, I have 9 specific slides on your questions, which you've asked previously, and we've got plenty of time to answer any other questions that you have as we go through. So unfortunately, there is a caveat tonight. This is an individual's perspective. It's a brand new system in the sense of the tweaks that have been made. And there's no experiences yet of what a gate check will be in terms of its process. We have had a mock one in the past up in Moray, but in terms of the new system, we don't know exactly what that will look like. But that will change soon, as I'll explain to you as we go through. Obviously, the following is it represents my summary as a Scottish Government reporter, but there is a lot of detail within the documents and the publications that I referenced tonight that you can go and have a look at yourself. Unfortunately, I won't be able to discuss, for obvious reasons, individual appeals or cases, especially those that are live, and I won't be able to give you a definitive interpretation of policy. But in general terms, I can answer questions as we go along. Well, who am I? I was born in Fife. I grew up in Aberdeenshire. I studied in Edinburgh and lived there for 12 years before moving down to the Scottish borders, where I am currently at the moment. I studied a 5-year degree, undergraduate degree, specifically in town planning. So I did 5 years, and you guys are getting an hour and a half tonight of what I kind of covered. During that, I had a year out working for Edinburgh Council. I'm a chartered member of the Royal Town Planning Institute. Now, why is that important? Well, it's important because I have to abide by a code of conduct, and that requires me to act in a professional manner with integrity, honesty, and fairness, and fearless independence. And that mimics pretty much a civil servant's code of conduct as well, for you to be aware of. I'm also an assessor of the RTPI membership. So anybody that wants to become a member has to go through a rigorous process to gain chartership. The reason I'm telling you that is because some of the competencies that planners need to prove before they could become chartered include an understanding of economics, an understanding of politics and planning, an understanding of sustainable development and the challenges of climate change and how those can be tackled. And key to tonight, an understanding of community engagement and the challenges to community engagement and the techniques that can be used to enable people to be involved in the planning system. I'm a past volunteer for Planning Aid for Scotland. I used to give advice throughout Scotland on weekends to community councils and others, and phone advice on certain planning applications. But that, in terms of my impartiality, had to be dropped when I became a reporter, as you can understand. I previously worked for the City of Edinburgh Council doing local and major applications, places like Craigmillar, down by the waterfront in Edinburgh. I worked on development plans when they were called local plans. And I also worked for a year as the departmental assistant to the convener of planning in Edinburgh, which gave me an insight from another side of planning. I've worked for the Scottish Government as a reporter since 2009, and you can see I've worked on a range of cases throughout the whole of the country. And I'll come to why that is in a second. So what is a reporter? Well, we're an appointed person. That's typically the terminology that's used in the legislation. And we're either employed as a civil servant or we're contracted to work for the Scottish Government. We work for the Planning and Environmental Appeals Division, and that's part of the core Scottish Government's legal directorate. But we work at an arm's length from government. So our main base is actually in Falkirk, and that's where the majority of our administration staff are based. But the rest of us as reporters, and uniquely to the government before the pandemic, we've all worked from home and continue to do so now. There's 23 salaried reporters, which includes a chief reporter, 3 assistant chiefs, 5 principals, and the rest, and then 15 self-employed reporters. And we're actually recruiting for more self-employed reporters in a minute. We come from a variety of backgrounds. Primarily, we're planners, but we're also ecologists, architects. We have heritage backgrounds and law backgrounds, and so on. Many of us have had a past history of where we've worked. In fact, one of my colleagues has worked for APRS in the past, the Countryside Commission, key agencies, national parks, local authorities, and the private sector. Each year we produce an annual review, and I provided a link at the bottom, but you can go onto our DPEA website and find that. And that gives an overview of what we do, who we are, what casework we've dealt with over the last year, and interestingly, the proportion of allowed and dismissed appeals, either taken from a planning authority level or in terms of case type. And you can look at that in your own time. I will be taking a few short pauses as we go through, just to let the information disseminate down into you, but also to allow, when we're recording this, for the recording to be broken up later on. So if I pause for a while, you're still connected. I thought we had to have a think about the planning system in terms of the history. In order to understand the present, it's important to understand that historical context. Why on earth do we have a planning system in Scotland? Well, as I understand it, post 1900, we had a system of bylaws and land ownership control, which controlled what development would happen across Scotland. Of course, there were problems there with slums, pollution, urban sprawl, ribbon development. And there were certain models through the Enlightenment period and the response to the Garden City movement to try and respond to that throughout Scotland and the UK. And there were enlightened thinkers throughout that time. It wasn't unique, those problems, to the urban areas either, as you can see from this Dunfermline Journal extract from 1903, that even in the Fife mining towns, there were issues of bad sanitation and uncontrolled development. So how to deal with that? Well, at the turn of the last century, there was a suite of housing and town planning acts that came out to try and address, primarily to begin with, housing need. Homes for heroes, for those returning from World War I in particular, might be of note. And then post-World War II, there was a New Towns Act and the Town and Country Planning Act of 1947. And those in themselves were interesting because they established a control over the property and use of land. In effect, for the first time, the 1947 Act nationalised the right to develop land across the UK. And then we can see from the 1970s, we start getting a Scottish flavour. And the key act for ourselves is probably the Town and Country Planning Act of 1997, which has been subsequently amended in 2006 and more recently in 2019. Effectively, what this did was it created a system where we looked at what we had and we prepared plans in order to plan for what we wanted and in the future. And then we would assess development against that plan, monitor how it went, and then start the process again in a secular manner. The key point is that in Scotland, we have a discretionary planning system. So while we might allocate land for housing or for other uses and set policies, there is room for interpretation. And that's to be countered against other systems throughout the world, such as zoning systems in North America, where there might not be as much discretion. So what recent changes have occurred? Well, National Planning Framework 4 now is part of the Statutory Development Plan, and it includes housing targets. The system now has removed what we used to call strategic development plans and statutory supplementary guidance, those elements that used to be part of the development plan. It's introduced local place plans and regional spatial strategies. It's also introduced a need for a local development plan evidence report and gate check, which I'll come to later on tonight. There's a requirement for delivery programs and a requirement, which is quite apt, I would say, for tonight's audience, for producing open space strategies and also assessing the place efficiency of a planning authority's area. It also allows for the introduction of infrastructure levies and consideration of health effects. You'll also see that as the years go by, there'll also be an introduction of more schemes of delegation. So things like development orders, certificates of lawful use, and adverts will no longer be appealed to Scottish ministers, but will come to local review bodies. At the same time that these changes have been implemented, the government has produced local development plan guidance, and I've provided a link to that right at the top of the chat, which you can have a look at. And also a circular, which is advice from ministers about local place plans. Looking at the development plan, in the past, the development plan comprised strategic development plans for city regions. So we had them for Aberdeen, Edinburgh, Glasgow, local development plans and statutory supplementary guidance. Now in this transitional period, the development plan comprises the National Planning Framework for local development plans and continuing supplementary guidance. But in the future, the development plan will only comprise National Planning Framework 4 and local development plans, and everything else will be a material consideration in decision making. I'm going to move on now and look specifically at the National Planning Framework 4 and give you a very brief overview of it. The first National Planning Framework 4 was published in 2009, and that was a non-statutory document, but it was unique in the sense that it provided a spatial framework for the whole of Scotland. Move forward to February 2023, and we now have National Planning Framework 4, which, as I said before, is part of the Statutory Development Plan. It's split into 3 parts. So part 1 is a national strategy, how Scotland might look in the year 2045. That looks at 6 spatial principles. It provides mapping indicatively for what the country, what developments may occur across the country. And it also has a narrative on regional spatial strategies. Part 2, which is the part that I would think most of you would be involved with and interested in, is actual policies, a suite of policies across the whole country covering sustainable, livable and productive places. Part 3 covers annexes, and those cover the national developments across Scotland, the spatial planning priorities, the 6 qualities of successful places, and uniquely it includes a minimum all tenure housing land requirement for each of the 34 planning authorities. There's a glossary as well, and that's important because we use that glossary when we're interpreting policy and making decisions. Just to give you a brief overview, here's in part 1, we have a spatial strategy for the whole of Scotland here. And you can see that indicatively it's showing where some developments may or may not occur. And then it outlines where the national developments are. Some of those of interest, perhaps number 2, the hydro scheme here, that's the Ben Cruachan Hydro Dam. And then down here, you've got the Hunterston strategic asset, which has been a mainstay of national planning frameworks since 2009. In part 2, you can see that we have a suite of policies. Many of these are new. They may continue themes of what we've seen in the past, but they're written from a national perspective, and they include things like tackling the climate and nature crises, and it tells us that significant weight should be given to both of those. It includes a policy in biodiversity and biodiversity enhancement, which in some ways mimics the biodiversity duty that's placed on all public authorities and decision-making bodies. There's a soils policy, which is fairly unique, and also community wealth building policy. All of these are quite interesting and new. I think from my perspective, what this does is it provides a consistency of policy throughout all 34 authorities in Scotland. Being a reporter and working across most of the authorities in Scotland and having to interpret all the development plans, there are very different policies in all those areas and nuances, which this, in a sense, irons out in providing a national overview. The policies themselves are then put into these boxes, which I'll show you in more detail below. So when you're looking at a policy, there's what I would call the intent of the policy. So in this case, it's the Greenbelt Policy 8 National Planning Framework 4. That is saying what the policy is about, what its intention is, and what the outcomes hopefully are, what ministers are hoping will be achieved through this policy. It then provides instructions for local development plans. So in this case, local development plans should do. So it gives advice to what a local development plan might need to research or do in advance in order to understand the Greenbelt policy situation. And then finally, on the right here, it provides the development management tool, the policy itself, which will be used to assess in terms of any applications and proposals coming forward. In part 3, for every national development, there is a statement of need. Now, national developments, again, uniquely, what being a national development means now in National Planning Framework 4 is that each of them, the principle of development is established. So we'll only really be looking at the detail beyond that. The statements of need provide a description of the development, where they are, why they're needed, what their designation is, and interestingly enough, their life cycle greenhouse gas emission assessment. Because again, National Planning Framework 4, as Claire was saying before, is looking to tackle the climate change emergency and nature crisis. Again, uniquely, as I said before, NPF 4 also includes a minimum all tenure housing land requirement for each of the 34 authorities in Scotland. That is nationally set for the first time, and it provides a baseline, the minimum which planning authorities will use to help set their local housing land requirements based on the evidence that they produce. I'm going to move on now to talk about local development plans. So obviously, as you know, local development plans together with NPF4 form the development plan. Each authority can produce one or more for their area. They're required to be produced as soon as practicably after the 2019 Act. So many authorities in Scotland are actively working on them right now. Thereafter, they're to be reviewed either by when they're directed to by Scottish ministers or at least every 10 years. And again, that's a slight change because previously they had to be reviewed every 5 years. So we've now got a longer period between local development plans. And I think that's why Claire was keen for you to understand when you should get involved, because obviously if they're only occurring every 10 years, that's a long period of time to wait for the next one. They should take account of the National Planning Framework 4, any local outcomes improvement plan for the area, and any registered local place plan. They also have to have regard to regional spatial strategies. Now, you can see here that ministers expect them to be place-based, so really they should be spatial, diagrammatic, with little wording. People-centered, and obviously people should be at the heart of them. It should be a collaborative process, but they should also be delivery-focused, so focusing on infrastructure needs and how those can be met to deliver the plan. The expectations for local development plans are very well set out in the local development plan guidance produced by the Scottish Government, and that covers absolutely everything to do with what the LDP process is, what a development plan scheme is, what evidence reports are, how the gate check works, what proposed plans are, what an examination is, how you adopt a plan. So out of all the documents probably tonight that I would implore you to look at, this one is very important. And as I go on to show you, this is one that will be used by the development industry and planning authorities to direct them in the future. So in terms of the overview of a process, to prepare your local development plan, it's a 3-tier process. So you have to gather evidence, you have to prepare the plan, and then you have to deliver the plan. So at the minute in Scotland, most authorities are at this stage or about to embark on it. They're doing engagement and they're collecting data in order to inform their evidence report. That will go to a gate check, which will be sent to Scottish ministers, and I'll explain that process in a minute. If they get through the gate check, or when they do get through the gate check, they will then move to preparing a proposed plan. They will then consult on that plan. And if there's any unresolved representations, and I'll explain that in more detail as we go on, but if there's any unresolved representations, there'll be an examination. And again, Scottish ministers will be involved. Beyond that, they'll adopt the plan, deliver the plan, and monitor the plan, and then they'll go right back to the beginning again. At the minute, we're expecting an influx of gate checks or evidence reports to come to DPEA from spring next year. I think 10 or 11 are anticipated. Beyond that, we think that once they get through the gate check stage, it will probably take about 18 months to get to the proposed plan stage. But obviously that will depend on resourcing of each local authority in Scotland and how they get on. So I mentioned earlier about a development plan scheme, and I want to highlight this as being a very important document. It's produced annually by each planning authority in Scotland, and an example here is Aberdeenshire's one. What this effectively does is it provides the dates of when they're hoping to engage with communities, key agencies, and other people, and it sets out each stage of the process, when they're going to engage with people, how they're going to engage with people, and what the outcome will be. And that's within the development plan scheme. Part of that is called the participation statement. And that's important when we get to the examination stage, which I'll explain to you later. But for your purposes, you want to be aware of what your planning authority's development plan scheme is. so that you can pencil these in. You understand when you're going to be involved in each process. And also, it will probably tell you how to be involved. It might ask you to sign up or look at a certain website or X or Twitter or whatever, but it will give you advice on how to engage in the process. So this is a vital document for you to be aware of if you want to be involved in local development planning. So when local authorities look to gather their evidence for the evidence report, they have to provide one now. They must seek the views of various people, including uniquely now children and young people and the public at large. The evidence report should set out the authorities' views on, and I'm not going to go through all of these, but just to highlight to you the housing need of the area, whether there's sufficient land in the area to accommodate that housing need, what the health and education needs and capacity are for in the area, and whether they have sufficient infrastructure to deliver what is required. The evidence report that they prepare should also include a statement on the way that they engage with the public at large and others, and expressly say how those any representations have been taken into account when preparing the evidence report. Once it's submitted to Scottish ministers, they'll appoint a person, i.e. a reporter like myself, and our job will be to assess whether the report contains sufficient information to enable the planning authority to prepare a local development plan. So it's a crucial stage. They have to get through that stage, and what we're calling it is a gate check. Now, during that gate check process, we could go to parties and ask for further information for us to understand any disputes in terms of the sufficiency of the information that's provided. The outcome is that either we're satisfied, in which case the local authority, planning authority, can go ahead and start preparing their local development plan. However, if we're not satisfied, then we will prepare a report that will go back to the planning authority and require them to revise their evidence report and resubmit before they can go on to prepare their local development plan. We have prepared a guidance note on gate checks, and as I said to you at the beginning, we haven't had one yet, so this will be a document that changes over time, I'm sure. But you'll note that our job, as we foresee it, will not be to test the overall sufficiency of the engagement process at that point, but just to ensure that parties have been engaged and the relevant stakeholders have been involved. Again, I implore you to have a look at the local development planning guidance, but you can see within the guidance, and this is just an extract on greenbelt, this is very instructive to planning authorities. So it tells them, because of this part of legislation, you should look at this. This is what National Planning Framework 4 is expecting you to look at. In this instance, local landscape character assessment documents could be of use to you. And then it's giving them considerations to think about in terms of compiling their evidence report. And then helpfully, there's a table, a schedule that they can all fill in. So for each topic, they can fill in what the topic is. So in this case, it'd be greenbelt, and then they can link the evidence. They can give us a summary of it. They can summarize the stakeholder engagement, which again is very important, implications for the plan, and then if there's any agreement or disagreement. And I would suggest that it's at this point that reporters in particular will be very interested. Areas of dispute in terms of the sufficiency of the information will be what we'll be honing in on during the gate check. I should say, so all these topics will probably, I would envisage, be compiled together to produce the evidence report. So the evidence report, I don't know how many topics it might cover, but it will be appended, and there may be a lot of associated documents that are linked to. So, assuming that a plan gets through the gate check stage, they'll then go on to produce a proposed plan. Now, when a local authority produces that, they must consult upon it. When they consult on the proposed plan, they'll probably at the same time consult on something called a strategic environmental assessment. Now, that document, the strategic environmental assessment, will assess the environmental impact of the proposals, the policies, the allocations, and the spatial strategy of the plan, among other things. That, for a reporter, is very interesting information, but our remit is not to look at the SCA and examine it. I'll come back to that in the future. If the local authority, after consulting, gets representations, then those may be in support, they may be against particular elements of the proposed plan. They can try and modify that by negotiation beforehand, but ultimately, if there's any unresolved representations, then an examination has to happen. Previously, we had something called Schedule 4s, but now they're called Schedule 3. The reason they're called that is because that's the schedule of the regulations that the template is set out in. So Schedule 3 templates will be completed by the authority for these unresolved matters. And generally, those are split into topics and or settlements. And if you've got any experience of an examination or looked at an examination report, you'll see these are all appended together, and they'll cover things like settlements or particular policies in a proposed plan. When we do an examination, an appointed person will carry it out, and the first thing that appointed person, the appointed reporter, will do is look at whether or not the planning authority has consulted people in the way it said it would in its participation statement. So that's going back to the development plan scheme, which contains the participation statement, which said what the planning authority were going to do, and we'll check that they've actually done what they said they were going to. So they said we're going to have a bus touring around the area with pop-up information, we're going to have workshops, we're going to use Twitter, we're going to use the website. If they haven't done that, then we'll write back to them and ask them why not, get clarification on it. But generally speaking, the authorities will set themselves up to do what they said they would do. We'll then go on to examine the issues in turn and prepare a report of examination. The examination process itself is limited to only assess issues raised in unresolved representations. We can't look beyond that. So if we're looking through a local development plan and we think, wow, I don't agree with that policy, or I don't agree with that, we've got no remit to look at that as a reporter unless there's an unresolved representation to it or to that matter. And that sometimes can create an issue of inconsistency. You might ask, well, why has a reporter made a recommendation on X, but they haven't looked at Y? And the reason we haven't looked at Y is because there isn't an unresolved representation to it. So we've got no remit to go there. I'd suggest that the usual process for a reporter in examining a plan would be to review the National Planning Framework for, firstly, the evidence report in the future. What does that say about the proposed plan? The content of the strategic environmental assessment, the delivery program in terms of the programming for, say, a housing site, representations received, documents submitted, the mapping of the area, and crucially, if it's a site that's allocated a site inspection. I'd say again, generally, rarely, in fact, I've never not visited a site that there's a dispute on. So we would do that to understand what's going on in an area. An examination in terms of the process is at the discretion of a reporter. Inquiries are highly unlikely. We've never had an inquiry on an examination. That's a process where people are cross-examined in terms of their evidence. Never had that for an examination. Hearings are possible, and typically those have been held in the past on housing. That may not occur in the future, depending on how gate checks work, and I can't foresee what may be a hearing in the future. But in general terms, a hearing's where we have an agenda issued by a reporter and we discuss matters around the table in a more informal manner than an inquiry. Further written submissions are likely where we have an exchange between parties, interested parties that the reporter identifies to get the information that he or she requires. And sometimes we have informal requests where we're missing a document or something and we need to ask for that from a party. Obviously, our report should be transparent, open and accessible, and hopefully succinct, although sometimes that's not possible in itself. What's new in terms of the new system is down here, that if we're unsatisfied that a proposed plan allocates sufficient land to meet the local housing strategy, instead of preparing our examination report, we can actually send a notice to the planning authority to ask them to prepare another plan. When it comes to recommendations, we can modify the plan, recommend it's being modified, or if we don't feel it can be modified, then we can ask the local authority to change it in another manner or take some other specified action. There are a few grounds for refusing reporters' recommendations, and those are if our recommendation would be inconsistent with what's in National Planning Framework 4 or a National Park Plan, if it would be incompatible with the habitat regulations, or if we were completely unreasonable based on the evidence that was before us. After the examination report's completed, the local authority has a period of time in which to review it and then go ahead and adopt the plan. And here's an example, Aberdeenshire adopting their plan in January of this year. And within that local development plan, there will be a proposals map or proposals maps or spatial diagrams that will show the allocation of land, either for housing, for business, for greenbelt, for open space. And it will contain a suite of policies. In this case, here's a policy on special rural areas, which encapsulates the greenbelt. And so if we had a proposal for something in the greenbelt, a decision maker would look at what this what the criteria are in terms of what permitted development would be allowed in the greenbelt. And now what they would also do is they look at National Planning Framework 4, and in this case, Policy 8 and greenbelts, and the two together would form the development plan in terms of decision making. And that's crucial because the Planning Act requires us to make decisions, particularly on planning applications, in accord with the development plan unless material considerations indicate otherwise. So that's important. Now, that's me in terms of local development plans. I'll take a pause for a second, but you can obviously think of any questions and we can come back to this at the end because there's a lot to digest there. So this is a new aspect to the Planning Act 2019 as well. In England, for quite a long time, they've had neighbourhood plans, and Scotland have adopted a similar approach in that planning authorities are now required to invite communities to prepare local place plans. These aren't part of the development plan, but so in a sense, they're non-statutory spatial plans, but they represent what a community would like to happen in their area. Once registered, a local place plan will be taken into account in the preparation of local development plans. And indeed, I would consider them to probably be a material consideration in decision making as well. There is a circular, as I say, on how to prepare local place plans, and the Transforming Scotland website has a how to do local place plans guide. There are very good resources out there. There's a blog on the Planning Democracy website about local place planning, and that in turn will give you some examples. Here's a registered place plan from up in Highland at the Strathethric and Foyers local place plan. And you can see, obviously it's a written document with a planning consultant helping the local, the community council, to prepare it. It contains plans of the area and then their aspirations for what should happen in those particular areas. There are tools which can enable communities to produce their own local place plans, including the Our Place and the Place Builder tool, which you can have a look at by searching through Google, I'm sure. Regional spatial strategies, these are discretionary in the sense that any planning authority or two can prepare them unless they're directed to do so by Scottish ministers. They're a long-term non-statutory spatial strategy. So they're not the same as a strategic development plan, which used to be part of the development plan. They are essentially informative. They have to set out the need for strategic development, and that's actually defined in the Act as meaning that those developments will have a significant impact on more than just the planning authority area itself. It should set out the priorities for the delivery of that development and the proposed locations in a spatial or diagrammatic way. Now, before they adopt those, they have to produce a draft. They have to produce a summary of the information that they've taken into account, and they also have to allow a period for representation. So again, there's another opportunity, should you be in an area which is producing a regional spatial strategy, to be involved in that production. Once they're adopted, they've got to be kept under review and refreshed at least every 10 years. Now, the two that I'm aware of at the minute are there's an interim regional spatial strategy for the Edinburgh region, and there's also a regional spatial strategy being produced for Glasgow and its wider environs. So those areas, of course, would have been the Southeast Scotland and Edinburgh strategic development plan area previously, and the Clyde Plan strategic development plan. So it kind of makes sense that they're moving forward with regional spatial strategies. So someone asked a question in advance of tonight's meeting about, am I being informed about something? Am I being consulted? Am I being empowered? And they weren't too sure. And most of the time, I think they were saying they were just being told something was happening, and they didn't feel that, they felt disenfranchised by the process itself. So another document for you to look at, or you may be aware of, is the government produced guidance on effective community engagement when preparing local development plans. And within that, it gives you different levels of engagement and participation, from are you being informed, are you being consulted, are you being empowered? And it explains what all those terms mean. And then helpfully, it shows at each stage of the plan process where you might be involved and what you can expect in terms of, are you being asked to produce something, or are you being told about something? That consultation wrapped up in September, but I would envisage that down the line there will be a final document that will come out. So from my perspective, a quick recap on when can you be involved in development planning. Well, you may be invited to prepare a local place plan, and that's your opportunity to say what you would like to happen in your community. You can provide representations to regional spatial strategies if you live within an area that's producing one. You should be aware of the development plan scheme for your area and the participation statement within it. And indeed, the local authority should ask for people's views on that document every year when it's produced. You should respond to the evidence gathering actions that are happening. And of course, you can look at the participation statement to see when those may be happening. You should provide responses on proposed plans if you wish and if you want to, and those don't have to be objections. They can be in support or net neutral. Be responsive if you're invited by a reporter to engage with gate checks and or examinations. Be aware of the local plan when it's actually adopted and its delivery program, which will be monitored and reviewed. I think it's particularly important to know when your local development plan has been adopted, particularly if you're interested in development happening in your area. And if you wish, you should also be involved in the suite of other non-statutory planning guidance that might be produced in your area and which planning authorities could consult on, including design frameworks, development briefs, master plans, design statements. So that was a very quick run through of the development planning system in Scotland. But that's not the one and only thing that reporters do. We have a suite of other caseload that we deal with. In Scotland, in terms of planning permission in particular, there are two routes to appeal. So if it's each local authority tends to have a scheme of delegation to their planning officers. So if there's a scheme of delegation to the planning officer and the planning officer makes a decision, then typically an appeal will be to the local review body, which will be made up of local councillors. Otherwise, if a decision is made by a committee and or the route to appeal is direct to Scottish ministers, then it will come to Scottish ministers. So that's if something is refused. It can also come to us for non-determination, which means that an authority hasn't made a decision within 2 months and hasn't given any indication to extend that period to make a determination. That's called a non-determination appeal, or ministers can call in decisions to reporters to make a decision on. So what do we deal with? We deal with planning permissions, listed building consents, listed building designations, like the Castle Car Park in Edinburgh, conservation area consent for when maybe you're demolishing something in a conservation area, anything like advertisements external to a building, so hoardings, digital hoardings that you may have seen in your area. If someone's doing something that maybe they shouldn't, they might be served an enforcement notice, and they have grounds of appeal for that. Maybe a property is in a state of disrepair, and so an amenity notice is served on the person to clean up the area or the building, and they can appeal that. Perhaps they've done works or want to do works to a tree, in which case they have an appeal process to us if it's refused. There are many disputes in Scotland over high hedges now, and those come to us as well. Completion notices compel people to complete a development. And again, you can appeal to us if you don't agree with that. You may have seen many certificates of lawful use or development in Scotland recently, particularly due with short-term lets. There's a route to appeal for us. And again, very rarely something called a revocation order, where an authority issues planning permission and then thinks, actually, we shouldn't have done that, and tries to revoke the permission. There's an appeal to us as well. We have a guide to all of our planning appeals in Scotland on our website, and we have a wider caseload as well. So beyond planning, we also deal with electricity generation, so things like wind farms, solar farms. We also look at electricity transmission lines. So the Bewley-Denny line, for example, in the past took many, many months touring around Scotland to have inquiries and oral sessions on that. Way leaves, compulsory purchase orders, community asset transfer of buildings, roads orders. So you may have seen a lot of the M9 dualling and the Aberdeen Western Periphery Road. Those came to us and my colleagues to determine or prepare a report to ministers on. We deal with pollution prevention control orders, stopping up orders. We do core path plan examinations, flood prevention schemes like the one in Dumfries, and rarely the extinguishment of public rights of way. So we have a variety of work, and either those are delegated decisions, for example, with the planning, listed building, and other decisions that I mentioned before. Those are probably delegated to us, unless they're recalled by the minister for him or her to make a decision on. These cases in particular will be report cases, so we'll provide a report to the minister and a recommendation, and it'll be for the minister of that particular portfolio to make a decision on that case. So I've just explained that in the case that most of our decisions are delegated unless the minister recalls them for his or her determination. We also deal with claims for expenses. So that's where a party has acted unreasonably, and that unreasonable action has led to an unnecessary expense of a party. And we can issue that. It could be a full claim for expenses, or it could be a partial one. So an example might be that something's refused for 5 reasons by a planning committee, and maybe one of the reasons isn't substantiated in any way. So we might say, look, 20% of the cost has got to go back, as an example. Now, when we make our decisions, or when ministers make their decisions, there is a route of appeal, and that's a statutory appeal or a judicial review, and those both go to the Court of Session, either to the outer house where one judge will look at it, or the inner house where 3 judges will review the decision. Right, that's the end of my run through. I thought at this point we could take a comfort break. That'll let you think about what I've talked about. You might have questions now. And if I say maybe 5 minutes, if you want to all come back, and then I can kick off with the questions and answer session. Does that sound okay? I'm looking at Nikki. I can't see anywhere else, or Kat.
Oh, I'll just say thank you very much for that talk, Alasdair. Loads of food for thought. There's lots of questions coming in on the chat. Everyone just take 5 minutes, wee comfort break, come back, and we're going to start on questions. I think it might be useful to perhaps tackle a couple that are coming through on the chat, and mix it up with some of your questions, Alistair, so we have enough time to do both, because I know that we've limited for time this evening. So perhaps we could pick a few out for you while people are on their comfort breaks. Anyway, we'll see you all back at about 7:05, if that's okay. While people are off on their comfort breaks, Nikki, I'm just thinking, if there's any particular things that have popped up, we can mix in with Alistair's questions to make sure we do cover them all in the next half an hour. How long, Alasdair, how long do you think your questions that you've prepared already will take to relate?
10 minutes.
Okay, right, good. Okay, well, that's fine. If we can just run through those in 10 minutes and rattle through, because there's been quite a lot of interesting stuff coming through.
There has. I've got a collection of questions, and I can group them together, but you may cover some of them in your first answers. So I can add extra ones if they're not covered in what you say next, Alasdair. So if that sounds all right, yeah.
Great. Well, I'll just go off and have a little comfort break, and then I'll introduce us all again at 5 past. Okay, I think it's coming up to 5 past, so we'll launch back in again. Thank you so much to Alasdair for that. I'm going to pass straight back to you for the questions so we don't take up any more time and we can get as much of this done as possible. The other thing to note is that Alasdair has very, very kindly agreed to answer any outstanding questions afterwards by email. So he'll be sending them to us and we'll send them out to everybody in an email after the event. And I don't know if that was a rash thing to offer, Alasdair, but we're very grateful to it because we knew that there'd be a lot of questions in this session. So handing back to you, Alasdair, for some of the questions that were submitted before the event.
Thank you. Just to clarify, you can all hear me again, is that right? Just nod of heads. Yes. Just before I get to those, I think I'm just going to jump straight in to Esme Cleland, our SPB Scotland's asked about the SEA. Just to clarify, so when we're examining a plan, we can't recommend any modifications to the SEA because that's not what's before us. It's the local development plan that's before us. But certainly the content of an SEA can be very important to our determination and our conclusions. And if that SEA was flawed or found to be flawed for any reason, then we would have to take that into account. An example, I had 2 sites beside one another in an authority area where an SEA said something about one site and said the allocated site was absolutely nothing on it. It was a plain site, but locals in that case, the local community highlighted to me that the SCA had got the 2 sites wrong, and actually the site that was allocated for housing was the one that had a high biodiversity value, and the other site was the one that was a former quarry or something. So SCAs sometimes can get it wrong, and they can be informative of examinations. And I think that example also highlights why it's important for local communities to sometimes be involved with local knowledge of the area. I'll just go to my slides now. Am I still sharing my slide here? Yeah, okay. So I've kind of grouped these together in terms of the questions that were asked before. So the first one up, are NPF 4 policies vague or of little use for decision making? Now, I answered this briefly before. My take on it is that NPF 4 provides consistency across the 34 planning authorities in Scotland. It contains a mix of policies, but also new policies. What it does is it's highly likely that we won't have, I mean, at the minute, we do have repetition of policies because we have old LDPs together with the NPF 4, but in the future, I would think local development plans will be far more streamlined, and therefore there won't be repetition of policies. It's a discretionary system in Scotland, so yes, there is room for interpretation of policy, but I wouldn't say that these policies are vague. I think they can be clear in what they're trying to imply. And certainly our use of them so far, they have been useful in decision making, but that's for each individual to take an assessment of. What's the balance between local place plans and local development plans? And this actually comes to some of the questions that are in the chat as well. So obviously local place plans are driven by communities. Local development plans, though, are required by statute, and those are driven by officials and approved by elected councillors. But the LDP must, and this is the legislative take on it, it says they must take account of local place plans. And that in turn imparts a value to the process of preparing a local place plan. I also think local place plans could be a material consideration in decision making. So they won't have a statutory effect, but they could still be taken into account. I think there's an interesting point about data. A lot of local place plans could be produced before evidence reports are produced, and therefore the data that they're using might not be the same. And that's something that might crop up in the future. In terms of, I think some people have asked in the chat as well about how glossy should their local place plan be? Is there resourcing for local place plans? Where can I get help about them? I think if you look at the Planning Democracy website, there's a lot more information in a blog on local place plans that will help you. on that particular point. Why doesn't the new system allow for local matters to be adjusted by use of supplementary guidance? Well, currently supplementary guidance, some of it is still statutory if it's associated with a local development plan. But as on the new system, supplementary guidance will no longer be part of the development plan and will no longer be statutory. So there is still room for bespoke policy making. Local development plans could include different policy takes to that in NPF4 were justified in local circumstances. But they need to be carefully crafted in order to ensure that there's no incompatibility with NPF4 unless that was desired. Now, the reason for that is because the Act says that the development plan is the National Planning Framework for local development plans. Where there's any incompatibility between the two, the latter will prevail. So any local development plan coming forward now will be the latter. And so if there's any incompatibility between what it says and what NPF4 says, the LDP would prevail in decision making. An option here as well is that a local authority can produce planning advice that's non-statutory. So you can still get a bespoke take on something, but it wouldn't be part of the development plan. Is there a conflict between economic growth, biodiversity enhancement, and community well-being? How do communities protect green space, and how is biodiversity enhancement going to be written into plans and used in decision making? Well, in reviewing NPF4 myself, primarily it talks about inclusive economic growth. And that, in my mind, imparts more than simply profit. It's talking about an inclusive, collaborative approach to growth. We have to remember that decision-making involves a balancing of usually social, economic, and environmental considerations. And I have to say, from my own experience, examinations have already recommended changes to biodiversity policies to ensure that the word enhance is provided within them. Biodiversity enhancement is already a consideration. All of us as decision makers in the public sphere have the biodiversity duty on us to look at biodiversity and ensure its enhancement. The term enhancement could be debated, but I think Policy 3 and NBF4 gives some good examples of what that could be. It says, where relevant, restoring degraded habitats and building and strengthening nature networks and connections between them. Proposals should also integrate nature-based solutions where possible. So that there are a few examples there already. And the open space strategies and other audits, I think, could be informative going forward in terms of that balance. Can housing still be released on greenfield sites? What is the commercial reality of not using greenfield sites? And why is there no presumption in favour of affordable housing? Well, the new system of a national planning framework it sets the minimum all tenure housing land requirement, which local development plans should find sites to accommodate based on their local housing land requirement. So it's a plan-led system where sites are allocated through the local development plan. And again, a change to the system now is that housing is supported on allocated sites by NPF4. And there are some exemptions, but they're not like they were before. You're not seeing exceptional release policies, for example, within NPF4. One exemption is that you could release a site if it complied with the spatial strategy for the area for affordable housing below 50 units. Authorities obviously can also modify their 25% standard requirement for affordable housing where justified. I would say that 20-minute neighborhoods, the brownfield first approach, local living, the nature and climate crises, the instruction to reuse buildings, those are all directing development to non-greenfield sites now in the first instance. But I think it has to be noted in terms of commercial reality that there are potential issues with developing non-greenfield sites in terms of urban environments. Are they contaminated? What's the previous use? what proximity do they have to other uses, and what does that mean for the viability of the site going forward? Why are valid concerns of rural people and local authorities ignored in regard to renewables? Does NPF4 give more weight to the nature crisis of the climate emergency, and how do wind farms fit with biodiversity enhancement? Now, I can't stress this enough. As reporters, we don't ignore individuals, communities, or local authority views. We take a very considered, careful, and managed view of anything that's submitted to us. We consider the evidence very carefully. We assess all proposals and developments against the correct tests, and we come to a professional judgment based on what's before us. And again, I go back to the fact that I'm a chartered town planner. I'm also a civil servant, and I'm bound by codes of conduct to the way that I act. So we wouldn't want to do that. I can understand that we have a succinct writing style, and in doing so, some people may feel disenfranchised by the way we write, how we've taken account of things. But I can't stress enough, we don't ignore points that are made, and we try and address them all. I don't think consultation on wind farms is a waste of time. I think there can be valuable insight from local knowledge and perspectives. And indeed, we try and engage communities when we have inquiries and hearings to take part in those processes. Both the nature and climate crisis are given significant weight by Policy 1 and NPF4. And one isn't given a different weighting in that policy. And Policy 11 on energy, it provides significant weight to the contribution of proposals toward meeting emission reduction targets. So we've got three significant weights when we're weighing up decisions on wind farms. In my own mind, what I've seen from practice is examples on wind farm sites of peatland and bog restoration, native woodland planting, bird protection, and habitat enhancement, which can all lead to biodiversity enhancement, potentially. We have a guide on other types of appeals and caseload that you can look at on our website if you want to know more about being engaged with wind farm or wind farm development. Why is planning not preeminent in other decision making? Well, simply put, I'm not going to go on about this too much, but planning is not the only statutory function of the councillor and indeed ministers. So there are other legal tests and duties that have to be applied, and it may be, for example, that planning is not involved in another decision-making process. So, for example, you might get a trading license for something but not get planning permission for change of use, or vice versa. You might get planning permission but not get your license. You might get planning permission to alter your listed building, but not get the listed building consent for the works because the tests are different. What can local groups do to protect the green belt, and how are trees protected on greenfield sites and in conservation areas? Well, as an overview, and as you'll all be aware, green belts don't need to encircle settlements. They can take various forms like wedges and strips and linear parks, etc. Generally speaking, there will be a greenbelt audit or review that would be carried out by local authorities to inform where development may or not occur or how robust a greenbelt boundary is. But communities can be involved in that, as can other organizations that have an interest in it. Trees can be protected in various ways. They can have tree protection orders on them, or indeed NPF4 provides a bespoke policy on woodland forestry and trees, identifying things like ancient woodland or trees of veteran status that will require protection. Trees in conservation areas, interestingly enough, are all protected. And if you want to do anything to a tree in a conservation area, you have to give, I think it's, don't quote me on this, but I think it's around 6 weeks notice before you lop, fell, or do anything to a tree in a conservation area. Otherwise, you can contact your local tree officer to find out more. Finally, are councillors accountable for their decisions? Well, in my experience, training is likely to be provided for all new councillors on planning matters. They should be, when they're on a planning committee, make impartial decisions, supported by their officers, be that planning officers, council officials, and lawyers. And of course, there is a code of conduct for councillors in terms of their acceptable behaviour. And if they haven't behaved acceptably, then that may or may not be an issue for the Ombudsman, and it could be a matter that's raised for a claim for expenses with us when it comes to appeal. So that's the end of my question and answer from before, but I'm happy to take any questions from tonight in the chat.
Thanks very much, Alasdair. That was really helpful, and you covered a lot of the questions that we'd received earlier already, which is brilliant. There are a few more from the chat, some sort of miscellaneous ones, and then a few really clarifications about a local development plan processes and LPPs as well. So a few miscellaneous ones. If there was approval for a development before MPF 4, but now the same development wouldn't be given approval or wouldn't likely to be given approval, is there any retrospective application of MPF 4?
Well, in general terms, if something has planning permission, then it has planning permission until its duration of consent runs out. So if it's got 5-year consent, then a developer would have 5 years to develop it. Well, sorry, to commence development. So to commence development, they would have to put a shovel in the ground and then notify the planning authority using a form. There is a particular form, and tell them that they commenced development. If they had commenced development, then in my understanding, that then means the planning permission has begun, and therefore it would continue in perpetuity. So, however, if the planning permission was to lapse, then they would have to reapply, and then MPF 4 would apply. But there isn't a callback. So if there will be many possible developments that have gone ahead that now possibly wouldn't go ahead, but you can't be recalled easily. As I said, there is a revocation order that that's part of the Planning Act, but if you were to do that, then there would be heavy compensation likely.
Okay, that's helpful. Could you say a little bit about the infrastructure first approach, what that means?
Yes, well, my understanding of infrastructure first is it almost exactly plainly as it says. So what you don't want to do is plan and then figure out that you need infrastructure and try and claw back some means of funding or whatever to fund that infrastructure. So I think it's about thinking spatially and in advance about what you need in terms of infrastructure to allow development to occur, and then planning for that. There is a national infrastructure plan for Scotland as well. And of course, this will feed into what the key agencies need in terms of waterworks, sewage works, roads, infrastructure, schools. So I suppose the gate check, in a sense, should help planning authorities to understand what their infrastructure needs are and plan for those in advance. So you're not getting into a situation where you're developing and the infrastructure isn't there to support the development.
Okay, thank you. A few clarifications on the LDP process. I can maybe ask a few questions and then you could answer them all. You mentioned the gate check evidence report. Is it going to be a public document? And I think you also mentioned in your talk that people or communities might get to participate in a gate check. Could you say a little bit about what that might involve? Development plan schemes, you pointed out how important they are because they set out the timescales for when everything with the LDP is going to happen. So they're important documents that every local authority produces. Somebody's asked, they tend to use Q1, Q2, Q3, but is that January to March is Q1, or is it a financial year? Sometimes that's not clear, and obviously that's important. Oh no, gate checks we've covered already. So those are on LDPs.
Yeah, no problem. Well, yes, of course, the evidence report has to be public, and the authority has to ask the public at large about it. So it will be publicised, and then when it comes to the gate check, it'll obviously be put on the DPEA website and made public. In terms of gate check participation, I would think that the same rules of engagement would probably apply for examinations, in the sense that we could seek information from interested parties as a reporter to understand any disputes. So it probably could take the form of written submissions or a hearing session if required. In terms of the development plan scheme participation statements, I'm not sure what you mean by Q1, Q2. That sounds financial, so it sounds like it's running April onward rather than January to December. But if you're in any doubt, just ask your planning authority what they mean.
Good advice. Thank you. A few have come in on local place plans. There's still a bit about, I think a lot of people, or maybe everybody, is slightly unsure what take into account means when it's being applied to a local place plan, and being taken into account during the LDP process. Somebody's asked if that has any legal weight. Also, there is a few questions relating to whether LPPs have to be reviewed ever. Are they meant to last 10 years? If you haven't done one before the next round of LDPs, is that it for 10 years? Is it meaningless to do them in the next decade? Or so?
Okay. Yeah. So there's several parts of legislation that say you must take account of something. What that means in practice, I think we'll find out as we go along. I can't say definitively what that means in terms of, but that's what the Act says. It says that local development plans should take account of local place plans. So we'll find out down the line. I couldn't give you a definitive on that, I'm afraid. Do they have to be reviewed? I'm not sure. I mean, looking at the legislation, I think they can perhaps be produced as much as you like. However, there is obviously the requirement to invite communities to prepare them. So I would anticipate that they're going to be prepared in advance of an LDP, so that they can then take account of the local place plan, if that makes sense. There are registered local place plans now, so local development plans will take account of those. I think, were you asking, there's recent local development plans, so a local place plan would have missed the buck in that sense, but those are old style, or those are local development plans that were produced under the old system or through the transition. They're not new local development plans, if that makes sense. So a local place plan would be taken into account in the next iteration of the LDP.
Thank you. That's really helpful. We've got a lot of questions in the chat that we don't have time for now, so I'm going to hand over. But we know that you've offered to answer questions that have come in that we haven't had time for, so we will let people have the answers afterwards. Thank you very much.
Thank you, Alasdair. I'm just going to wrap up now, because we've only got 2 minutes left. But I'd like to say a big thank you to Alasdair for his comprehensive talk. It's not easy to fit it all into one session. I recognise that there's quite a lot of questions still to be answered. I would really, really recommend that you do go on and read some of the documents that we will be sending to you, which includes APRS's guidance, if you like, on the local development planning, and the blog on local place plans, because those will both answer quite a lot of the questions that have come up in the chat as well, and may provide an additional perspective. It's not necessarily our perspective will be the same as the DPEA, so we will be trying to answer some of the questions as well, to give you our perspective on that as well. So I would just like to put one final plea in. Neither APRS nor Planning Democracy have very much funding coming in this year. We really could do with some donations to both organisations. I believe that Barry might be putting the links into the chat, but if you are moved to give us a donation, we will be very welcoming of that. So thank you to everybody for coming. Thank you to Alasdair for delivering such good presentation, and thank you to APRS for doing the background hosting and some of the background work with us as well. Take care all.